Welcome. Today is Monday, May 6, 2019. My name is Mark Depew. I'm the Director of Oral History at the Abraham Lincoln Presidential Library. And today it's my honor to have Mitchell Roth here with me. Mitchell, good afternoon.
Good afternoon, Mark.
You and I are going to be talking about the Illinois Education Association's views on a subject I did, of an interview I did with Mark Janus, who was the plaintiff for, as you know, for the Janus versus AFSCME Supreme Court case, which had a big impact on public sector unions in Illinois and across the United States. I always like to get both sides of the story, and so here's our opportunity today to get, although you weren't involved with the case directly, the Illinois Education Association wasn't, certainly the IEA has felt the impact on that, as has the NEA across the country. So it was fair to me to ask you to have an opportunity to come in and express on behalf of IEA their views on it. So always like to get a little bit of background
Okay.
and find out why and how you ended up working for IEA in the first place. So
Sure.
let's start at the very beginning. Tell me when and where you were born.
Well, I was born in upstate New York, in Albany, New York, in 1952.
And tell me a little bit about growing up and going to school.
I grew up in a very small town in upstate New York, and our elementary school was right there, within walking distance. The middle school and the high schools were a bus ride or a car ride away, but it was a very positive experience, my public education experience growing up.
So always public schools.
Always public schools.
Were either of your parents involved in unions?
My dad was. My dad actually worked for a television and radio station in upstate New York for about 25 years. And he was a steward, a union steward. I think it was the electrical workers that had organized them. I'm not 100% certain, but he was fairly active.
Is that something, a conversation that came up at home very much?
Not so much, a little bit, but I certainly saw what he did on a regular basis and started to develop an appreciation based on that.
How about college?
College, I went to Princeton University for my undergraduate degree.
And did you know when at your undergraduate level what you wanted to do with your life?
Um, well, it evolved. I started out as an engineering major, changed that to become ended up a psychology major with an economics minor.
And then you graduated from college. What did you do after that?
I took a year off. When I went through college, I worked my way through college, and one of the jobs I had was working in the dining halls at the university, and so picked up a good amount of experience, became a manager of the dining hall, one of the dining halls there, and then for the about 7 or 8 months afterwards, after graduating, was employed in working on some personnel matters and personnel issues and policies for the dormitory and food services of the university. And so that was the immediate year, and then I traveled some before I started graduate school.
I don't know if I even mentioned in your introduction, you are now the general counsel for IEA.
I'm general counsel, right?
So the question is, why law school?
I started to develop, as I was going along, an interest. I had done I had a thesis to do as an undergraduate, and I did it on the attorney-client relationship to get my psychology degree. And then when I went to graduate school, I was in a master's program at Cornell University in labor relations. And I realized going through that program that to really do the things that I wanted to do in the labor relations area, a law degree would probably be the best way to do those things.
Where did you go to law school?
University of Wisconsin.
So you had from day one when you got to law school in your mind that you would be working in labor law.
I hope so. One of the reasons I chose University of Wisconsin was because it had a few more labor and employment offerings than other law schools I was looking at, and of course I got in there. So But that was one of the big reasons I had looked at Wisconsin, was because of the labor and employment offerings.
What year did you get your law degree?
1980.
And you took your bar exams in what state?
Well, going to University of Wisconsin, if you go to Wisconsin Law School, you get automatic admission, assuming you graduate, into the Wisconsin bar. But I had taken a job at that time with the National Education Association in Washington. And so the summer after I graduated from law school, I took the DC bar and passed it, and then worked at NEA.
Any particular memories of working at that level at NEA?
It was a wonderful learning experience. I worked with some outstanding attorneys. I got to really dabble in a lot of different areas of labor and education law and employment law, as well as some other things. I got to travel a good amount, but it was just a good entry for me into an area that I had developed a passion for, and I enjoyed getting out in the field, traveling around, going to different states and meeting state association staff as well as the members of our union.
Speaking of getting out and visiting the states, then what led you to Illinois?
In fact, what led me to Illinois was back in, I think it was 1985, Illinois IEA, Illinois Education Association, had its first fair share case that had been filed against it by objecting fee payers to what was being charged them. And I came out on behalf of NEA to assist in litigating those cases. So that's when I was first out here in Illinois and met some of the staff and leaders of the Illinois Education Association.
I assume most people who are watching this are going to understand what fair share is, but I think it might be helpful to explain what that means.
Well, what it is, it's in Illinois and a number of other states, by state statute, by state law, employees who choose not to be or who chose not to be members of the union under state law could be charged sort of a fee to cover the costs of representing them that the union was required by law to do. And so here in Illinois, it's called a fair share fee. Some other places it's called an agency fee. But that's the concept, is that people who choose not to be members but are required to be represented by the union can be assessed a fee to cover the costs of representing them.
So your very first thing that you're doing in Illinois, it's going to tie directly to this case that's going to come up a generation or more later.
Pretty much so.
And what I wanted to do next, and I know you and I had talked about this, I think it's important that we kind of lay out the case law that led up to this in the first place. So I'm going to go all the way back to 1947 and the Taft-Hartley Act.
Even before I was born.
Yeah, me too. I wonder if you can tell us a little bit about the implications of the Taft-Hartley Act in this regard.
Well, it had a provision, and still has a provision in it, that allows states across the country to pass right-to-work laws, which basically stand for the proposition that if that law is passed, that somebody who chooses not to be a member cannot be compelled to be a member of the union or to be assessed a fee to represent them. And the Taft-Hartley law applied purely to private sector employees, but not to public sector employees.
Then the next thing I wanted to ask you about is an important decision that came down from the courts, 1977, so this is a generation after the Taft-Hartley Act, but it's the Abood versus Detroit Board of Education. Tell me about that case and why that was so important.
Again, that was before my time at NEA. It was right when I was starting law school. But that case was of critical importance because it was the first time among public employees that the question of could a union constitutionally charge these people who chose not to be members a fee to cover the costs of representing them. And in that Supreme Court case, the court decided that yes, it was constitutional to charge those individuals, even though it might impinge on their First Amendment rights of speech and association. It was constitutional to be able to charge them for that, as long as the activities and the expenses were for things related to collective bargaining, contract administration, and grievance processing. The court also said at that time that one of the things that the union could not charge these, what are they called, objecting fee payers, was for anything that was political or ideological that was unrelated to collective bargaining. So that's kind of the line that the court drew at that time.
In other words, they couldn't collect money and then turn around and support a political campaign.
Correct. But what the court, basically said is for fee payers, they would have to object to the expenditure of their money for those causes, and then you'd have to somehow reduce their amount of money that you were assessing them.
And this is an obvious answer to this question, and it precedes both you and me in terms of our involvement, but what was NEA's position on that question and IA's position on that?
I assume both organizations were supportive of the decision. I think for IEA, it probably wasn't even on the radar screen because that was prior to Illinois even having a collective bargaining law and any sort of law that allowed for fair share in that way. So it probably wasn't even on IEA's radar screen.
I know a little bit about the story about Illinois' position on both right to work and fair share. I know that during the Walker administration, Dan Walker administration was for 72 to 76. He had an executive order that allowed for collective bargaining for public sector unions. And I know that in 1982, under a Republican governor and a Republican Speaker of the House, George Ryan, he attempted to pass a right-to-work legislation. In other words, what you were talking about before. And you're smiling here a little bit. Do you remember how that came out?
Well, again, it was before my time in terms of how that panned out, but certainly it wasn't successful in terms of passing any type of right-to-work legislation here.
In fact, a very memorable conversation with Governor Thompson, a Republican, who has a great story that illustrates what had happened with that particular piece of legislation. It didn't make its way out of the Illinois House, and he had promised to veto it if it had. Okay. So the climate in Illinois was never very optimistic in that respect.
Yeah, and Jim Thompson was the governor when the collective bargaining laws were passed in 1983. So
right, exactly.
And very supportive of it.
And he was proud that he got union support in his election in 1982 and 1986. So.
Yeah, and I think it was more than necessarily his support of a collective bargaining law, that it was many more issues that led IEA and other unions to support him at that time.
Yeah, he was actively courting support of the unions. There's no question about that. The next one I have down here, and I don't know much about, 1984 Ellis versus the Brotherhood of Railroad Employees. Is that something that you can add any light on?
Again, that didn't deal with, it's an important case in the Supreme Court jurisprudence on fair share. It dealt with basically whether organizing expenses, organizing new groups of employees could be charged to objecting fair share fee payers. And it dealt with it under the Railway Labor Act as opposed to any state labor act. But the decisions dealing with fair share or agency fee under the Railway Labor Act sort of informed decisions dealing with fair share when it came to public employees. So it was an important Supreme Court decision when it came to what could be charged to objecting fee payers and what couldn't be charged to objecting fee payers.
Okay. The next one I have on my list, I think you are now part of this agency that has an impact on this. This would be 1991. Tell me about the Leonard versus the Ferris Faculty Association case.
And before we get to Leonard's,
okay.
There's another case that's of critical importance in the fair share cases that the Supreme Court handled, and that was the Hudson case, Hudson versus Chicago Teachers Union, which was 1986.
Okay.
And what that case dealt with what sort of procedures did unions have to have in place to basically inform fee payers of what their rights are in terms of making an objection to what the union was assessing them, and then what sort of procedures were in place to be able to challenge those determinations. Because again, in the fair share law that had developed, a union could charge actually 100% or up to 100% of what it would charge for dues. The only way that fee would be reduced is if a fee payer made an objection, either a religious objection or a political objection to the payment of the fee. And so what Hudson dealt with is what sort of information did the union have to provide fee payers in order to make an intelligent assessment of what the union says it's expending its money on, and then the procedure to challenge that. So that came in '86 before the Leonard case. But then the Leonard case was the next one, as you pointed out, in 1991. And that really got down to the nitty-gritty of trying to draw the lines between what a union could legally charge objecting fee payers and what it couldn't. So it broke it sort of down into chargeable expenses and activities and non-chargeable expenses and activities. And it went through a number of different types of union expenditures and activities and to try to draw those lines. So that's what that case was.
Okay. Now, my next case I wanted to ask you about is 2012. That's almost recent history. Now, I might be overlooking a couple others, which I'll be happy to have you correct me on that. But the 2012 Knox versus Service Employees International Union, Local 1000, and that was decided in June of 2012.
Right.
What can you tell me about that case?
You know, that was a fairly specific issue in that case, and what it involved, to my recollection, was what sort of information a union had to provide to fee payers when in the middle of the year it tried to up the fee it was charging them. And I think in that situation it involved a union in California, Service Employees International Union in California. And I think they were trying to raise some additional funds to be able to campaign against a particular initiative that the governor at that time was trying to have pushed through. And California is a very big initiative state, as you well know. And so, unfortunately, the union in that case did not provide sort of a new notice of to fee payers that it was going to do this, how it calculated that fee, how it was going to expend that fee, as the Hudson case had basically required, and the Supreme Court found that was a problem.
A crack in the union's armor, perhaps, at the time, or would that be overstating the case?
You know, I'm not quite sure I'd say a crack in the armor. I think it was, in my personal opinion, sort of a mistake that SEIU did in that circumstance, to not go through all the procedural requirements in terms of increasing the fee. But it was sort of an indication that maybe of where the court was sort of now going in terms of its thinking when it came to fair share.
And it seems to me that up to this time, the courts had decided firmly on the side of labor unions, on public sector unions, but I don't need to tell you that the membership in the court evolves over time as well.
It does.
And that's going to, I think, very much play a role in this. So the next case takes us back to Illinois here. Harris versus Quinn. And this Quinn is Governor Pat Quinn, a case that was decided in June of 2014. Right. Tell me about that case.
Well, that basically involved whether fair share could be charged to a certain segment of, what were possibly seen as public employees at that time. And they were home health care workers. And it was challenged. Some home health care workers challenged whether they could be assessed a fair share fee. They didn't feel that they were the same type of public employee as state workers or school district employees or that sort of stuff, and they challenged therefore the legitimacy of being charged a fair share fee And understand that in Illinois, there are two acts. There's the Illinois Educational Labor Relations Act, and then there's the Public Act, which covers state employees. Both those laws just sort of generally authorized the ability to have a fair share agreement in a collective bargaining agreement. It didn't require that there be a fair share agreement in a collective bargaining agreement, and that was left to bargaining between the union and the state, or the union and the school districts, on whether they would include a fair share provision in the collective bargaining agreement. And so in the collective bargaining agreement covering these particular home health care workers and assistants, a fair share agreement was put in place, and these people challenged it, and the court said that didn't recognize these employees as truly public employees who could be covered by a fair share agreement.
Okay. I wonder if you'd be willing to talk then about Justice Alito, who came out at the time and obviously had some pretty strong views on the subject and kind of set the stage for other people to be encouraged to pursue lawsuits in the future.
Right, and Justice Alito has been on the court since 2006 or 2007, and so I believe he also authored the majority opinion in the Knox case, and so that was his first real chance to sort of author a majority opinion in the fair share area and to sort of make some comments regarding fair share. The next opportunity was, of course, Harris versus Quinn, where he authored that majority opinion and more strongly expressed his reservations about the constitutionality of charging fair share fee payers any type of fee. He had expressed a little bit of that, I suppose, in the Knox case and in some of his rationale, more so in Harris versus Quinn, but Harris versus Quinn did not present an opportunity for the court at that time to take on the overall constitutionality of fair share, because what the Supreme Court really tries to do in its decisions is just to focus on the specific issue that's before it, and just deal with the constitutionality, if it's a constitutional case, of what's specifically raised before it. And so that's what was focused on in Harris versus Quinn, and that's why it didn't go beyond that. But that doesn't prevent justices from writing in what's called dicta, that sort of language that doesn't directly address the specific issue, but may somewhat be related to it, express some of their views on the underlying concepts.
So that wasn't a position he had taken in the majority decision? It was something that came out external to that?
Well, basically, he didn't have to assess the constitutionality, and the court didn't have to rule on the constitutionality of fair share overall. It only had to deal with, in Harris versus Quinn, the specific issue of whether these home health care employees were in fact public employees who could be covered by a fair share agreement in a collective bargaining agreement between the state employer and the union. And so the court was not going to take on the broader issue because it wasn't specifically laid before it, and really hadn't been briefed in the lower courts, which is another thing that the court tries to do. It will not typically address issues at the Supreme Court level that haven't had a chance to be litigated in the court below. And so those are some of the dynamics that were going on.
Would you agree with this statement that what Alito did was invite future cases?
I think there are people who do feel that he was inviting. He certainly was indicating where his views were. Hard to know how many other justices at that time supported that, but yes, he was certainly giving some sort of invitation.
Well, this is where Mark Janus comes in.
Mm-hmm.
Mark Janus was employed at the Department of Healthcare and Family Services in Illinois. He had been there for quite a few years. As you know, I've interviewed him. He expressed surprise when he first started working there that they were collecting fair share dues. But it was several years later, after he'd been there, that he finally decided he wanted to initiate a lawsuit about the same time that Governor Bruce Rauner had initiated a similar lawsuit. Um, as you know, they decided that Governor Rauner's lawsuit did not have standing, but that they were willing to consider, as it works its way up through the courts, Mark Janus's case. So I wonder if you can, well, let's back off from that, because this is where we get into the tactics or strategy of pursuing a lawsuit. Because about the same time, California had picked up the initiative as well. I should say some teachers in the teachers union in California. Were they part of the NEA? Were that affiliated with the NEA?
I think you're probably talking about the Friedrichs.
Friedrichs versus California's
Friedrichs case.
Teachers Association.
And the California Teachers Association is a state affiliate of the National Education Association.
Okay. What can you tell me about that case?
Well, again, that case was finally the issue of the constitutionality of fair share was raised before all the courts, the district court, the federal appellate court, and then the Supreme Court. And so the issue that ended up being decided in Janus was really first most directly presented and specifically presented through the courts in the Friedrichs case.
So it made sense for Mark and his legal team to wait to see how the Friedrichs case would be decided?
Oh, I think I understood the strategy on that. I think, with Mark's case, as you were talking about how it sort of evolved, I mean, when Governor Rauner first came in 2015, I think within his first week or two, he did a number of things. One of them was to file this lawsuit challenging the implementation of fair share under the State Labor Act. So he filed that lawsuit against the state. So it was the governor suing the state. The state was defended by the Attorney General, and in defense of the lawsuit that the governor had filed, one of the things that the Attorney General raised was whether the governor, in fact, had proper what's called standing, meaning was he so adversely affected or personally affected by the implementation of fair share in this situation to have that sort of personal stake and interest in being able to be a proper plaintiff in the lawsuit. And within a short period of time, from my recollection of the Attorney General filing that, Mark Janus and two other state employees filed to intervene in Bruce Rauner's lawsuit. And that was in March or April of 2015. And then what happened in that case, once Bruce Rauner was finally dismissed out of the lawsuit because the judge agreed that in fact he didn't have the requisite standing, the judge also at the same time said, I'm going to not only, since there's no case to intervene in anymore, I'm going to basically turn Mark Janus's and the other two employees' motion to intervene in Bruce Rauner's lawsuit into basically a separate lawsuit, which I will entertain. So.
Okay. I know in conversation with Mark, the issue has come up a lot, accusations that Mark was basically recruited by the Rauner administration to participate in this. Mark has always denied that he was doing this separately on his own. I can't speak to the other two plaintiffs who eventually dropped out of that.
Right, and I don't know. All I know is the timing was what the timing was. And if you look at the district court's decision, which dismissed Bruce Rauner, allowed Mark's lawsuit to move forward, and then dismissed it. The judge did raise some, just throw some shade on that also, and said it was, didn't basically say that there was a connection there, but they said that, I think he said something along the lines of, and I've got it here, that the governor began a series of procedural maneuvers obviously designed to establish jurisdiction, which was to try to prevent his lawsuit from being dismissed. And it says, first, the employees, and that was said Mark Janus, undoubtedly with the governor's blessing, intervened in the lawsuit. So that's all I know is what the judge said and the timing of the issue.
Okay. Speaking of timing, now you've got the Friedrichs case. It is argued in January of 2016. And cases of that impact, I don't need to tell you, typically the decision is announced by the court in June. And the more important the decision, it tends to be later and later in June. So that is certainly the case for the Friedrichs case. This has national implications. And as things would happen, Antonin Scalia passed away in February, a month after the case was heard in Washington, D.C. So in June of 2016, the decision comes down, only 8 justices, because Scalia is not part of the equation. It's a 4-4 split. It goes back to the federal court, I believe that's the Ninth District Court, which had held in favor of the union.
Correct.
So it's still somewhat in limbo.
Right.
Did I get anything wrong in that, laying all that out?
No, I think that was, I think that was basically it. There's debate on what Justice Scalia, on which side he would have come down. There were a number of us, including myself, who believed there was a distinct possibility that Justice Scalia would in fact had decided in favor of the union. And, in part that was based on, we had talked a little bit earlier about the Leonard decision. Justice Scalia was one of the justices who decided in favor of the union in that case. He had a concurring opinion, which was he concurred in the judgment, the ultimate judgment, but he had a little bit different rationale than the majority opinion or the plurality opinion had in that case. But he basically upheld the concept of being able to charge individuals who are not members but who benefit from the union's representation some sort of fee. So based on that, if he had been consistent with that, his rationale and his reasoning in that decision, I had some hope that in fact in the Friedrichs case he would have decided with the unions.
Well, hope suggests that there was also some doubt. What would lead you and others to have some doubt about how Scalia would come down on it?
Justice Scalia was an unpredictable justice.
And would it be fair to say he is also typically viewed by many, especially on the right, as the conservative lion on the court?
Clearly he was, no question about it.
Okay. I don't know if you want to address anything about it's not obviously Mark Janus who's taking this case up. It's an expensive proposition. If you wanted to talk at all about the legal team and the legal support he had.
Just to say, I know he had representation from the Liberty Justice Center, which basically is, I would call it sort of a legal entity that has been created by the Illinois Policy Institute back in 2011, 2012. And I think that was a primary source of his legal representation. But also the National Right to Work Legal Defense Foundation, which has been in existence for 50 some years. And so those were the two entities that I believe provided the primary legal representation for Mark.
Organizations that characterize on the right side of the political spectrum?
Clearly supported by donors, contributors who tend to be on the right side of the political spectrum. I don't know all the donors that certainly the National Right to Work Committee, the National Right to Work Legal Defense Foundation is sort of the litigation and legal arm of the National Right to Work Committee, and is very clear in terms of what its purpose is. The National Right to Work Committee, we know what it's about. It's about, about educating and taking and doing litigation and legislation to try to stop employees from being compelled to belong to a union or to pay a fee to a union. And its litigation arm, the National Right to Work Legal Defense Foundation, basically goes out and files lawsuits or defends lawsuits in that area. And they're very clear on their website and in all their literature that that's what they're doing. The IPI and the Liberty Justice is not as clear in terms of what they say their stated purposes are as the National Right to Work Committee and the National Right to Work Legal Defense Foundation. But both, I think, groups are funded by, as you said, right-leaning conservative donors. For example, the Illinois Policy Institute, former Governor Rauner, a significant donor. Richard Uihlein, a significant conservative donor. The Mercer family, I believe, was a donor to IPI or some of the subsidiary organizations that IPI has had a hand in creating. And the Donors Trust, which the Koch brothers have some significant involvement in. All, I think, have donated money to IPI or affiliated organizations.
Illinois, as you talked about already, had a long tradition of not being a right-to-work state. It had been defeated soundly back in the early 80s, and it was really never considered be after that time, even though, as you know, Governor Rauner was pushing for that and had absolutely no traction, I would think it's fair to say. That was not the case in some surrounding states around Illinois. I wonder if you can touch on that, and I don't know if that has much of a bearing on this, but...
Well, I think, a number of states, Michigan was one state, Indiana, Wisconsin, Iowa, Missouri most recently. All of them, the political climate in all of those states was different when either restrictions on collective bargaining, as has happened in Iowa and Wisconsin most recently, but in those other states as well, and right-to-work laws were passed. Not the climate here in Illinois. Illinois has historically, and I'm not saying those other states didn't have a good history of supporting worker rights, including collective bargaining, but Illinois has had, a solid history that continues. And to be honest with you, it's more than just Democrats in control of the governorship and the legislature, because, as we talked about earlier, the governor who was in office at the time the collective bargaining laws were passed, and fair share was included in them, was a Republican, Governor Thompson. Mm-hmm. So what has happened around us has, in terms of those states, has not had any type of significant impact here.
What I wanted to do now was to read at least one statement here from Roberta Lynch, who is the executive director for AFSCME, American Federation of State, County, and Municipal Employees. That's a mouthful.
It is.
And whether or not you want to respond to this is fine, and because IEA is a different organization, but obviously both IEA and AFSCME and SEIU in the state of Illinois are going to be affected by how this is going to be sorted out. Mm-hmm. So here's what Lynch said. The powerful interests behind this case have tens of millions of dollars to pour into their political agenda of trying to silence us. We're making certain that every union member knows the real intent of this case is to defund unions, then drive down wages and benefits of public service workers. Mm-hmm. Would IEA generally be supportive of that
view
statement?
I certainly would. I think IEA probably would. If you look at the groups who were funded Mark Janus's lawsuit, as well as are active across the country, the Illinois Policy Institute, for example, is essentially a state, I don't want to call it affiliate or what of a national a state policy network that exists out there across the country. Michigan has the Mackinac Center that's its IPI, for lack of a better term, and they have come out with documentation written information out there that their goal is to weaken public sector unions and unions in general. So I think Roberta's statement is pretty accurate in terms of what we believe the motivation is behind this.
Well, again, in my interview with Mr. Janus, he was clear that he didn't have anything against unions. He felt unions played a role, but he didn't agree with many of the things that unions are trying to do. So what I wanted to turn to next then are some things that he has told me, and get you to respond from the IEA's perspective on what he was saying. And here's the first statement. According to him, I was defending my constitutional rights of freedom of association, which is to say it's the First Amendment, and that is why it is part of the Constitution. I felt that my inability to freely associate with who I wanted to, in this case the union, which was taking my money without my permission on a mandatory basis, I felt was a violation of my rights. And that is really the core of what his issue was.
Right. I have no reason to doubt the sincerity of Mark's belief and why he did that, why he filed the lawsuit. I would just say this, that the law that certainly existed pre-Janus basically allowed, whether it's the Bood case from 1977, as well as other public employee speech cases in the workplace, that allowed some sort of restrictions on the First Amendment rights of public employees when it came to workplace issues. And so our belief was, well, I don't doubt Mark's sincerity, was that certainly the case law, the constitutional law, permitted the state and the exclusive bargaining representative of the union who was representing him to, in fact, assess a fair share fee and do, many of the activities that we were doing, that AFSCME was doing, and that we, did for, across in school districts, without infringing on his constitutional rights, because the case law that had existed for years basically said that there could be some limitations on public employee First Amendment rights when it came to workplace-related issues.
Okay. Here's another statement that he made. You have to live within your means. Now he's getting into some of the positions, especially in the collective bargaining, and how he's talking about the fiscal state of Illinois, which I think almost everybody would agree is not good. You have to live within your means, and everyone knows the state of Illinois hasn't lived within their means. We haven't had a balanced budget in this state in I don't know how many years. And he goes on and makes some comments about how big a hole that the state has. Any merit in that part of his argument?
Well, you mean in terms of the concern of living within the state, needing to live within its means? I think, of course, we all would like to see that as best as possible, but the state also has a lot of demands in terms of public services that it's called upon to do. And those people we elect as governor, as legislators, make those sort of policy decisions. And, if we don't like those policy decisions that they make, in terms of a decision to provide for collective bargaining, to provide for fair share, then the mechanism for dealing with that is at the ballot box.
Okay. I appreciate you mentioning the Hudson Agreement here, because that's an important part of what he's talking about next. Because one of his concerns was, okay, I have to pay my fair share, but 80% or more of what the union is collecting, that's part of the fair share. So here's what he said. The Hudson Agreement spells out what that fee is being used for. However, the line items are so innocuous and so vague that you really don't know where the money is going. They have a line item, I remember, called advertising. Well, what is advertising? And then he continues on a little bit later. How do I know that my money was not going to some kind of political campaign and the like?
Well, I think Mark, a couple of things in terms of a response to that. First, Mark had a mechanism in which to challenge what the union said, how it expended its money. Because, as we talked about earlier, a fee payer could make an objection and then challenge the union's calculation I believe under the state law in front of an arbitrator, an independent arbitrator, under the Education Labor Relations Act, it would be in front of our Education Labor Relations Board. And every year, IEA and our locals that assessed a fair share had a hearing in front of our Education Labor Relations Board in which we had to justify through a lot of documentation how we expended our money. Mark had that opportunity to do that. It's my understanding, I don't know if this is a fact, it's my understanding that Mark never made use of the process in which to challenge the fair share that he was assessed, to sort of ferret out exactly how the union was expending its money.
Do you know if the union made any effort to inform its members that they had that option?
I have no doubt that AFSCME did in fact do that.
Okay. He was also concerned about the union's defense of workers who were being disciplined. And this is something you hear quite a bit in terms of a criticism in unions, that they're protecting incompetent workers, that it's making it very difficult for people to be dismissed or discharged. And here's specifically what he said. The union would defend them in such a way and fight for it that it became almost impossible to get somebody out of there. Any comments on that particular concern?
It's not just Mark who has made that comment. I've heard it for 4 years, and I think it's an unfortunate and an unfair comment. I know from our perspective in terms of the Illinois Education Association, whether it's in our contracts or it's in statute, because for education employees there's some what's called due process protections that are built into either state law or into collective bargaining agreements. And that's what we try to make sure that an employer is adhering to, that an employee who is having some difficulty is giving the opportunities to better themselves, notice of what the problem is, and fairly treated. And then if that, in fact, that doesn't work out, they're dismissed, then they're dismissed. But much of these cases in terms of discipline are just the union basically taking a matter because the employer did not fully comply with either state law or with what it agreed to provide and follow in the collective bargaining agreement. You know, the comments that you can never get rid of a public employee are just false. I mean, we have education employees who get dismissed, and there are clearly state employees who get dismissed.
Some of these things that I just read, that concerns that Mark had about his union, obviously weren't going to be things that were specifically addressed in the case itself.
Correct.
What I'd like to have you do, and I don't know if you're in a position or want to do this, but to kind of summarize AFSCME's position going into the Supreme Court case, going into those oral arguments that they had.
Well, I think, AFSCME, and it wouldn't be unlike us if we were the main party and had been the main party in that case, and the unions who were supportive, but others. There were a couple of things. I mean, AFSCME, understand that fair share, the ability to have fair share, was a state government decision. That, in fact, when the law was passed, the state of Illinois was making a decision that it believed that it was in the best interest of labor relations in the state, in the public sector, whether it be school districts or it be at the state agency level, for there to be collective bargaining between the state, the employer, public employer, and the union that represented its employees, and that a fair share fee was reasonably assessed to those people who didn't want to be members but were still benefiting from that bargaining and other representation. And understand that also in the state law is a requirement that a union that's what's called the exclusive bargaining representative of everybody in a particular bargaining unit has to represent everybody in the bargaining unit, whether they're a member of the union or they're not a member of the union. And so based on that, I think the state assessed that it was fair, since the union has to represent everybody, to assess even those people who choose not to be a member some sort of fee to cover the cost of representation. And so I think AFSCME came from, certainly came from the standpoint, hey, we have to represent everybody. And therefore, it's only fair, and the state has enabled us to do this, to assess a fee to cover all the activities, all the expenses that we do on behalf of everybody in the bargaining unit, whether it's negotiating the contract, whether it's taking a grievance, whatever. And so that's, first and foremost, that's I think was an argument that AFSCME certainly made. I think AFSCME, made the arguments that and I agree with this assessment. It wasn't an infringement on those non-members' First Amendment rights. There had been 40 years or even greater of Supreme Court decisions that have basically said this is constitutional to do this, to assess a fee, and for a state to enter in these sort of arrangements that, while it might be seen as an infringement on a First Amendment right, the state's interest in having stable labor relations and a union that was a partner in terms of bargaining and administrating contracts, to have a fee to sort of help them defray some of those costs was fair. And so I think AFSCME certainly came from that perspective. Another perspective that both AFSCME and I know IEA and NEA came from is that really a state should be able to determine and structure its workplace as it believes is best, and that is constitutional. There's one of the amendments in the the 10th Amendment is states' rights, and there's a lot of deference given to states, and has over the years been a lot of deference given to states in terms of administering their own affairs, their own internal affairs, which includes the services they provide and the employment and the workplace that they establish.
We mentioned before the importance of timing. So now you've got the death of Antonin Scalia, you've got a split decision as far as the Friedrichs case is concerned. So as far as Mark Janus and his supporters in the Janus versus AFSCME case, that's the next one on the docket.
Right.
And so now it depends on how the 2016 presidential election ends up. Most people figured that Hillary Clinton would be the next president of the United States. One of the powerful arguments for people to vote for Donald Trump was that he promised to support the appointment of conservative justices. And in fact, the surprise of the last 100 years politically perhaps is the election of Donald Trump, which now it's not going to be Merrick Garland who's going to be the next Supreme Court justice, as you know, that Barack Obama nominated Merrick Garland long before the election.
Correct.
And the Republican Senate decided not to do anything about that, so he was not appointed to the Supreme Court.
In an pretty much unprecedented move.
And now it's going to be
Neil Gorsuch.
Neil Gorsuch. Thank you very much. Suddenly my brain cramped
That's
up
all right.
on me here. And he is nominated. The vote is 54 to 45. And another breaking of precedent, that's the first time that there wasn't a 60% or 60 member vote.
Correct.
To appoint him. But he is now on the U.S. Supreme Court. Now what did you think? What did the supporters of AFSCME and IEA think about the chances for the Janus versus AFSCME case?
I mean, we felt that certainly Justice Gorsuch was not going to be as favorably disposed as Merrick Garland likely would have been if confronted with the same issue about the constitutionality of fair share. But I wasn't 100% convinced, maybe it's my eternal optimism, that in fact that Gorsuch really made it a 5-member now majority to do away with the constitutionality of fair share, because he was there were some of his decisions as an appellate court judge which he was for 10 years before being appointed to the Supreme Court, that could have gone both ways on some of the key issues. And then I personally wasn't sort of convinced that one of the other justices, whether it be a Justice Roberts or a Justice Kennedy, might become more moderate or be more consistent with some of their prior decisions when it came to this issue.
So as we lead up to the oral arguments, which are going to be January of 2018, I believe.
Right.
Were you now hearing, was IEA hearing from the members of your union about this case and what they wanted to see?
Well, I think everybody was concerned, certainly, because it was really, it had progressed. There was, and it looked like with, Gorsuch being on there, that, and the court took the case. I mean, it, didn't have to take Mark Janus's case. It didn't have to accept a review of it. It did. And then with Justice Gorsuch now on there, we were probably, I know I personally felt less comfortable than I felt with the Friedrichs case, because with Justice Scalia, again, as we talked about before, I had hearkened back to the language that he had used and the rationale that he had used 25 years before in the Leonard case, where he had upheld and spoke favorably about the constitutionality of fair share. So with Gorsuch, we didn't have that at all. So I think we were certainly more concerned about the decision.
I understand that NEA, probably IEA, issued an amicus brief. If you know anything about the position, that would be great. But also, what's the role of the amicus brief in this whole process?
I mean, basically, those briefs are what are termed friend of the court briefs. And in this case, in the Janus case, there were, I think, about 24 or 25 amicus briefs that were filed on Mark Janus's side in terms of supporting, the argument that he was making, sort of giving a little bit different view than was necessarily argued in Mark's main brief. The same thing on the AFSCME side. There were almost 40 briefs that were filed by various unions, by government officials, by academics, all supporting the constitutionality of fair share. And so NEA and IEA signed on with NEA's amicus brief, basically argued from the perspective of what we had talked about just a moment ago, that states really should be allowed to structure their workplaces, their labor relations, as they see best, and that a decision to do away with the constitutionality of fair share would basically take that authority away from the states, authority which many states had used. There were probably 27 or 28, I think, and maybe it's a little bit less, states that allowed collective bargaining, allowed fair share, and had done it for years. And so, and had seen the benefit of a much more stable relationship and better working relationships with their employees as well as their unions. And so our concern was that that would destabilize, or potentially destabilize, labor relations across the country.
Okay. In our conversation up this point, there's two main issues that I understand, and I'm certainly not a lawyer by any respect. One was the freedom of speech challenge that the case was making, and I think you've done an excellent job of kind of laying that side of the argument down. The other one was freedom of association. And first of all, where in the Constitution is that?
Well, it's not specifically in the Constitution. It's basically, and I think it's about 60 years old, the Supreme Court case, which really established the concept of freedom of association. And it's sort of seen as part of freedom of speech, but also freedom of assembly, and also part of, liberty interests under the Due Process Clause. All of those basically came together for the court to establish the concept of freedom of association. But they're very intricately intertwined, and the same arguments typically are made. And I think Mark was basically making here that compelling him to be a member of the union, to support the union, was compelling his association with the union, and was compelling him to support the speech of the union, and that both of those were a violation of his First Amendment rights.
Okay. So we've laid out the arguments. We know how AFSCME and how IEA were feeling about these arguments.
Mm-hmm.
How about the stare decisis? Am I pronouncing that right?
You are. And again, that goes back to the Abood decision from 40 years before. Stare decisis is essentially precedent, and it's basically a concept that courts really defer to precedents, prior court decisions, particularly those that have become well established in the culture, as our view Abood has, and that parties, private parties, public, governmental entities have come to rely on over the years and structure their relationships. And so the Supreme Court, as well as other courts, have been adverse, for the most part, to disrupt that precedent, that stare decisis, except in very rare circumstances. And unfortunately, the U.S. Supreme Court in Janus saw that that was an opportunity to do that here in the case.
Okay. What I wanted to do, I found a statement that was National Education Association made about some of the concerns that organization had going into the announcement of the decision. One was that it would further rig the economy against working people. And I don't know if you want to address any of these or not. They're clearly not legal kind of issues, but if you want to take a pass, I understand, but raise it anyway. The economy against working people, rig the economy against working people.
Well, I think the feeling was that, and I'm a full believer that unions, organized labor has helped working people, working individuals through gathering their voices together to have more impact in terms of policy in the country, and in terms of their working conditions, and policies that impact their lives. If it's just one individual, their voice most often is never heard. But if you get a group of individuals together, which is what a union is, their voice is better heard and often will have certainly much more impact. So I think there was a concern that this would undercut that, and I think that's what's being expressed there.
Well, I think you've already led into this next one. Limit the freedom of workers to join strong unions.
Yeah. And I think, it's getting, again, at the same thing, the financial support for unions. Unions continue to have to represent everybody in the bargaining unit, but now only members, as opposed to all the people in the bargaining unit, members and non-members, pay. And so it becomes much more expensive and sometimes too costly to be able to provide the panoply of services. And so that was a concern there, that the union would financially be weaker to be able to take on all its responsibilities that it's required by law to do.
Okay. Next one. Give more power to corporate special interests and CEOs.
I think that probably went more towards the fact that the entities that funded the representation, as well as entities across the country who on a regular basis are working either legislatively or through litigation against unions, that they were in a better position because unions conceivably would be weaker by taking away some of their funding. And so,
but we're talking about public sector unions. This sounds like it's addressing private sector unions.
Well, but I think, if you look at it, certainly Janus was a public sector union case, but the activities of these very conservative right-wing groups who have been working legislatively, PR-wise, litigation-wise, while it may have focused over the past years on public sector unions, private sector unions are also in their crosshairs as well, for lack of a better term. But public sector unions have, over the past certainly 15, 20, 25, 30 years, had, I suppose, greater influence in terms of public policy than private sector unions, because private sector unions, probably since the early 70s, have seen a decrease in their membership, whereas public sector unions have sort of held their membership fairly constant, and therefore have been for lack of a better term, a bigger thorn in the sides of those people who are in opposition to us.
Okay. Further increase income inequality in our communities.
I think that just goes to the fact that unions will not be as strong to bargain good collective bargaining agreements to the benefit of their members and those they represent. But unions also, whether it's the NEA family or whether it's, most other unions, it's not just, strictly their members that they are out there advocating for in terms of policy and other things. It's for the middle class, and in terms of bettering the lives of the middle class, those individuals and those less fortunate than the middle class, whose voices just aren't heard. And so taking the union voice away, weakening unions, in our view, weakens their voices as well.
Okay. And the last one I had here, hurt our educators' ability to make schools better.
Well, I think, we are firm believers, and I do believe there's been research, in fact, fairly recent research out of UIUC that shows that union in the public sector and with public education, unionization as well as collective bargaining has been a positive benefit to achievement in the public schools. And so I think our concern was when you weaken the unions, when you weaken what can be gained through collective bargaining, it has the potential of weakening the public schools as well.
Okay. So we're still in the lead up, the months before, perhaps after the oral arguments, we're now waiting for the decision. Were you surprised at all by the amount of public attention this case was getting?
Not so much. I mean, I think there'd been a buildup. I think whether it was those people who were in support of the case were making it a much more public issue. I think they saw also that they had what they felt was a good chance that they would be successful. And I'm not saying it's Mark Janus was doing it, but I think those individuals who were financially supporting the entities who were providing legal representation, as well as others around the country, were making this as big an issue as became. And I think public sector unions felt concerned about how this may come out. So not so much surprised by the attention that it got. There's a lot in the news media that doesn't surprise me these days that gets attention.
Yeah, about that. Well, it is a case that's going to impact potentially millions of Americans, correct?
Correct.
Millions of public sector unions across the entire country. What was the conventional wisdom of IEA and NEA while you're in early June waiting for the decision to come out?
I don't know if it's conventional wisdom or not. It was apprehension. Again, not knowing how the decision would come out, fearing that there was a greater likelihood that it would come out the way it did. But I honestly still held out hope, whether it was for Justice Gorsuch or it was for Justice Kennedy, because Justice Kennedy had authored several majority decisions over the years which upheld restriction on public employee First Amendment rights in the workplace. I mean, it goes back, for him, it goes back 30 some years in terms of cases that he authored. And so I thought, to the extent that he would be consistent with what he had expressed in his rationale in those decisions, if he was to be consistent, I believed he could be a favorable vote for unions. Now, there were a lot of people who didn't agree with that, and if you looked at the oral arguments, he was one of the more aggressive justices when it came to challenging the state of Illinois as well as AFSCME in their oral arguments. And not that you can always tell from oral argument on how a justice is leaning, but as it turned out, that was a very good indication of where he was leading.
But Kennedy had decided with the conservatives in the Friedrich case, is that correct?
Well, he had been among the four
Okay.
in the Friedrichs case, correct.
And I know at the time there was some speculation, and you mentioned this before about which way Roberts would go, and certainly Gorsuch is the new person on the course.
Correct.
So, June 27th, right at the end of the term,
Right.
I think the last day, was it not?
I think it was the last day they were issuing decisions,
Yeah.
correct.
A 5-4 decision, and in the majority are Roberts, Kennedy, Thomas, Gorsuch, and Alito, and writing in favor, obviously, of Mark Janus.
Correct.
And in opposition, Kagan, Ginsburg, Sotomayor, and
Breyer.
Breyer. So now what's the reaction immediately? What's the mood in IEA at that time, that day?
Well, disappointment, but not surprise. I mean, we had thought that there was a distinct likelihood that was going to happen, but we had planned. We were covering our bases both ways, but we had we had established a process by which, once the case came down, there were certain steps we needed to take, because we wanted to be crystal clear that this is the court's decision. We did put out things to our membership and to our staff about the decision and held some discussions, but we immediately communicated with all our local associations as well as school districts that they needed to immediately stop collection of fair share fees. And so that was really the first thing out of the box, that once that decision came down, that fees were no longer constitutional. It was no longer constitutional to collect them. We wanted to make sure that our locals and those school districts with which we had agreements stopped collecting fees.
Okay. Went into effect for July of 2018?
Hey, June 27th.
Okay.
That's when it went into effect. So any fees that we might be collecting for the rest of the 17-18 year had to be stopped. And to some extent, we had, in some of our school districts, we collect over 10 months or 9 or 10 months a full year's worth of fees. And so we were clear that where we did that, we had to refund to any fee payer the amount that was collected for those months after the Janus decision came down.
And I know this was part of the decision. I'll let you clarify this. Was there anything that a fair share member had to do to opt out of the union?
No. I mean, basically from the point that the decision came down, we were no longer legally able to collect fair share fees from people who didn't want to be members of our union, but were in the bargaining units that we represented.
And here's something else you've already talked about, but just to clarify, once the decision comes down, is there any relationship between that non-union member and what the unions can do on their behalf?
It did not change the whole concept of what's called exclusive representation and the duty of fair representation, which meant that the union was still the exclusive bargaining representative of everybody who's in the bargaining unit that the state has certified them or to represent. And so we had, and we still do, have to continue to represent them as if they were a member, essentially. We can't differentiate between our representation between somebody who's a member and somebody who's a non-member when it comes to bargaining the contract, administering the contract or processing their grievances.
How about a disciplinary issue that might come up?
For the most part, most disciplinary issues are under a collective bargaining agreement, and so to the extent that those discipline procedures are under the collective bargaining agreement, non-members as well as members have to be represented in the same way. Now, for those disciplinary procedures that may be outside of the collective bargaining contract, the requirement to represent members and non-members the same way is that doesn't exist, because it only exists in terms of those things that you are required to represent a bargaining unit member on, and that's related to collective bargaining, anything in the contract, processing grievances. It doesn't deal with statutory rights.
I guess I'm a bit confused. Can you give an example where they would not be represented by the union if they had some kind of disciplinary?
For example, the IEA, for tenured teachers in Illinois, there is a process, there is a state statutory process for a tenured teacher. It's called the tenured teacher dismissal process. That's totally under statute. It's not under the collective bargaining agreement. So for a tenured teacher dismissal hearing, we are not required to provide the same sort of representation to non-members as we are to members. In terms of discipline less than dismissal, for example, that might be covered under a collective bargaining agreement. So, for example, a non-member who's a teacher gets reprimanded, or gets a written suspension or something like that. And there's a provision under the collective bargaining agreement that deals with that sort of discipline in terms of the process. In that case, we would have to represent a non-member teacher in the same way, in challenging that sort of reprimand, in the same way that we would represent a member. So
Okay.
that's the difference.
I know that there are some cases for AFSCME where fair share members actually joined the union right after the decision came out. Was that true for IE8 as well?
It was. I mean, we had fair share fee payers who joined not only afterwards, they were no longer fee payers after the decision. They were, just non-members who decided to become members of the association. But we also had fee payers prior to the Janus decision convert from fee payer status to membership status.
I read in the Wall Street Journal here recently that there's something like 210,000 formerly fair share members who are no longer part of a union. Now, that's across the entire country.
Mm-hmm.
Do you have a sense of what the impact was in IEA?
I don't in terms of a number. I think that the Wall Street Journal number clearly was people who were former fee payers. But I know here in IA, I don't know how many fee payers have decided to become members. I don't have that number. I do know that this year we have seen we have continued to sign up new members in this organization. In fact, even at a little bit greater rate than last year or the year before. So we haven't seen that sort of
Has it changed the strategy for how the union approaches potential new members in that respect?
I don't know if it's changed the strategy. I think something that we have been trying to do for many, many years is what I call reconnect with our members, and I assume that's now translated into reconnecting with people who haven't yet chosen, or connecting with people who haven't chosen yet to be a member, to having those sort of one-on-one conversations with them, getting to know them, getting to know what is important to them, getting to know what they value, and how, and trying to help them see how we can, value in being a member, and how it can help them get to the things that they want to achieve as a public educator. So, but that was really going on before the Janus decision.
I was struck the day the decision came down. Suddenly there was this flurry of attention that the case got, and then suddenly all of that disappeared because Justice Kennedy decided to retire the same exact day, and that became the focus of attention.
Yeah, and for to me, for a short bit of time, it did. But and I'm not saying that attention didn't continue to be paid to that, because he had been on the court for probably 37 years, something like that. And he was, seen as sort of a moderate to conservative justice. His retirement had been anticipated. I don't think anybody fully expected it would be right then and there, but then there was all the speculation of, well, who's going to take his place and how is that going to tip the court maybe to a more conservative bent. But there remained significant attention to the Janus decision. I know certainly from our end, in terms of all the things that we were doing, we were paying much more attention to the Janus decision than worrying about who was going to be filling Justice Kennedy's spot. And I think overall, as the summer went on, that sort of balanced off.
I'd give you an opportunity, if you want, to share what the NEA or IEA had put out as an official position after the Janus decision came down.
Yeah, and there was one thing that I pulled, and it was an immediate, I don't know if it was a press release or a statement that NEA had put out, and I'll just read a couple of paragraphs. And it says, the collective voice of American workers was undermined today by the U.S. Supreme Court's ruling in Janus versus AFSCME. In a 5-4 decision which casts aside decades of precedent and laws, the court has eliminated a public sector union's ability to collect fair share or agency fees from workers who choose not to join as union members but are still protected by union agreements. The ruling undermines the ability of educators to come together and bargain collectively on behalf of students. And then there are two quotes here that I think are important quotes from the NEA president. The first is, "A strong union and collective bargaining agreements are what help to ensure students receive the tools and resources they need to succeed in school and in life. We've seen it in the resources available to our students, and we have felt it in our paychecks." Then she goes on to say, all over the country they are cutting funds for the arts and PE, up-to-date textbooks, recess, and class sizes that allow for one-on-one instructions. Many of our schools have faced serious funding cuts that are likely to grow even worse. Collective bargaining has been a critical tool to push back against these cuts and demand the resources our students deserve.
Okay. We're just about done today, but I have one other question I want to ask you, and do something that historians typically don't like to do, and maybe lawyers don't like to do that either, but to maybe look in the future and predict what the outcome, what the impact is going to be in unions. So let me put it this way. Are you optimistic about the future of IEA?
I'm very optimistic about the future of IEA. I look, and I say that as I'm retiring from IEA this June, at the end of June. I'm very optimistic. I look at the policies of the organization. I looked at the energized membership and staff and leadership of the organization. The same, and the passion that they have for, the work that they do, educating students, giving them a high quality public education. And I also see the community support that has rallied around us and other public sector unions, and the support that exists out there for public sector unions. So I am very optimistic about our future.
Well, thank you very much, Mitch. You've been an excellent spokesman for your institution, and I'm
Thanks,
sure
Mark.
they'll be happy with the results of this interview. And it's an important piece of history for us to get both sides of what I think is a landmark decision in American history. So thank you again.
I appreciate the opportunity. Thank you.
And thank you for being with us today.